Good morning. I wanted to just quickly go through, I'm going to walk through actually, a little walkthrough, because Lively has filed a proposed jury instruction for this mixed motive defense. So I just want to kind of walk through that. So if we start back at the judge's order, basically denying Lively's motion to exclude a jury instruction on mixed motive affirmative defense. That's here, and it's just this little bit here actually. So for the reasons provided on the record, etc., court denies. The court denies Lively's motion to exclude a jury instruction regarding same decision on mixed motive affirmative defense. So what is a mixed motive affirmative defense? That's basically what that's going to look like is this now opens the door that Wayfarer can argue and say, look, even if you think that we smeared her and it damaged her reputation, we would have done it anyway. And not because of any protected activity. They're basically saying, look, we would have made the same decision. And they will argue then she put Baldoni in the basement. She refused to promote the film, except through regular threats of extortion. She turned the cast against him. So on and so forth. And clearly she had her eyes set on the sequel, because we know that Ryan Reynolds in October, and I think this is what made her decide to file the CRD, that around October 2024, Ryan Reynolds attempted to buy the rights to It Starts With Us. And that deal did not happen, right? So we can presume Baldoni said no. So there was going to be a sequel. There is clearly now not going to be one, because I find it wild that Lively, in her testimony has said, well, no, I just could not stand the thought of, standing next to this guy or sitting next to this guy and doing interviews with him or any kind of promotion, but yet she still thinks there is hope of some kind of sequel. So much so that she is basing that as part of her damages and lost opportunities. And that just shows me a level of delusion with Lively. So basically, the mixed motive affirmative defense, it just allows an employer to avoid liability in discrimination cases, which this is, by proving that they would have made the same employment decision, even if an impermissible factor such as, race or gender had not played a role. They're saying, look, if you find that we have smeared Blake Lively, then we would have been doing it because of all these things that she did, and they would get to argue those things. And then the jury it kind of says, look, you can't just assume we would have done all this because she complained about sexual harassment. And it just made Lively's case a hell of a lot harder, because what was closer in time to the quote unquote smear campaign? Was it her complaining of sexual harassment, or was it her being a dickhead through the promotion? And you see, the thing is, this is where Shusty's video actually is quite important, in my opinion, because when Shusty did that interview, it was for another film. I can't remember. I'm sure people will tell me in the comments. I can't remember, because I honestly, I'm not that invested in Blake Lively's acting career. But the interview was part of a movie promotion, and she was acting like a complete idiot, an entitled brat. And now we're seeing a pattern of this. So It Ends With Us movie. I keep saying It Ends With Us movie. It Ends With Us was not the first time that she's been, difficult during a promotional interview. And I think Wayfarer will say, look, actually, this happens, quite frequently. Blake Lively promotes a film and just comes across as really mean. And, they'll have they'll probably cite to her interviews about A Simple Favor, where she was with Anna Kendrick. There was a couple which were a bit eye-raising, and they will try to show there's a pattern that Blake Lively, during the promotion of a film, is just an asshole. So, but in this case, though, Justin Baldoni was not just the actor; he was the director of the movie. So, if the movie came across bad, if the actors who were hired to represent the film came across bad, then it kind of makes him look bad. Also, his studio was financing and producing the movie, and it all goes to his reputation and the reputation of Wayfarer as a studio. So, why do I think that they stipulated? Again, I did say in my video, but I will say again, I do think it's very strategic, but also I do think they really had no choice. And for that, we'll go to the motion for summary judgment decision from the 2nd of April. Here, Judge Lyman actually said himself, when viewed together, he'd gone through all the incidents, and basically he was saying, look, several of the incidents would either not support a hostile work environment claim or would do so, at most, only minimally or in context. But then he also says, the court begins with the former before turning to the latter. When viewed together, the incidents are sufficient to support a reasonable basis for Lively's complaints, and therefore her assertion of a retaliation claim. So Lyman himself says, look, when you put them all together, you can kind of see where she's coming from in terms of having a reasonable basis for complaining. And that argument could have then been put to the jury and persuaded a jury, potentially. But by stipulating that and just saying, look, all right, for the purpose of the trial only, in the jury instructions, we'll say Lively, we'll agree, Lively had a reasonable basis for complaining. It wipes out a lot of the witnesses, the experts, and, various pieces of evidence that would be about, the incidents of sexual harassment. So Lively does not need to prove that now. So we've just done away with a lot of evidence, which we see how Lively kind of argues it and how she distorts it, right? And there are some pieces of evidence which, individually, as Lyman says, you're like, God's sake, don't be ridiculous. But, there are some that some jurors may think, yeah, I can see it, actually. That's inappropriate. And it gets rid of testimony such as Michael Robbins. I don't know for sure, but I expect his expert testimony won't be needed now, because he talks about largely, the actual sexual harassment incidents, the role of the intimacy coordinator, SAG-AFTRA rules, the CRD guidelines, and, all the ways that he, in his opinion, Wayfarer failed. And all of that should now go, because we're going into this with a presumption that whatever happened, Lively had reasonable basis to believe that there was a complaint to be made. So we've skipped over that. Okay, so we've gone through all that. There's a reason I've gone through all that. That's because Lively has filed said proposed jury instruction, which she was supposed to file yesterday, but she actually filed it in the early hours of today. And it's a little bit of a protest. It's a 4-page letter to say all the reasons that she still doesn't agree with that the judge is allowing this, but and then you've got an attachment then with her proposed instruction. So, okay. So, dear Judge Lyman, pursuant to the court's authorization at the April 28th, 2026 pre-trial conference, Plaintiff Blake Lively respectfully submits concurrently herewith a proposed instruction regarding defendant's request for a same decision mixed motive jury instruction on plaintiff's FIHA retaliation claim. Ms. Lively reiterates the objections previously raised in her proposed jury instructions and her supplemental letter brief dated April 17th, 2026, namely that a same decision mixed motive instruction is either waived and or not applicable on the facts of this case. Thus, Ms. Lively submits this instruction over Ms. Lively submits this instruction over objection subject to and respectfully requesting further briefing and argument at the close of evidence. So she is still not happy about this, and she is still trying to say, look, Judge, I know you've already ruled on it, but I want to talk about it further. So we continue. Ms. Lively respectfully submits that, separate from the issue of waiver of the defence, a same decision mixed motive instruction is legally improper here, because this is not a mixed motive case. For a mixed motive instruction to apply, defendants must identify and prove a lawful motive that exists for an adverse employment action, entirely independent of protected activity. And if Blake Lively thinks, so what she's saying here is she's trying to say, well, look, even if they try to raise the defense of Lively taking over the movie, she's going to say, well, yeah, but it's still a crossover of the sexual harassment. She did that to keep the set safe, blah blah blah. It's in her 17-point list. And the thing is, right, is if Blake Lively is trying to blur the lines between her feeling that she was sexually harassed and within her right to complain, while simultaneously demanding her cut. Like, how is demanding your cut of a film that you were not asked to cut up, make a cut of a film? How is that anything to do with sexual harassment? And for me, the fact that Lively's even raising this, just again, it confirms what we all knew, which was the allegations, the sexual harassment allegations, really were leverage to take control of the film. Okay. Lively continues, they have not done so. The asserted justification traces back to Miss Lively's harassment complaints or other protected activity. Where's it? We do have sorry, one sec. Okay. This is clear from the court's own characterization of the defense, finding that defendants have consistently asserted that their conduct was not directed at retaliating against Miss Lively for her prior complaints of discrimination, but in protecting themselves from what they consider to be her false and defamatory comments about them. And we have a footnote. Miss Lively respectfully submits that, while it is true that defendants have always asserted their conduct was in response to an alleged false narrative about them, they have steadfastly insisted that they did nothing but advance, we keep going, positive narratives about Mr. Baldoni, or otherwise neutrally monitor social media. Asserting a same decision mixed motive defense requires them to take a quite different position, i.e., that in the event a jury finds that they engaged in conduct that is legally beyond reasonable defensive measures and in fact constitutes an adverse employment action, they had a legitimate independent reason for doing so. This is not a position they have consistently taken in this case. But the false and defamatory comments about them are statements that constitute Miss Lively's protected activity, as this court also recognised in ruling on Miss Lively's motion to dismiss defendant's first amended complaint. In that decision, the court noted that the Wayfarer parties claim that Lively spread a false narrative that Baldoni committed sexual misconduct toward Lively and the Wayfarer parties, then engaged in a smear campaign to ruin her reputation. Okay. Yeah, so Lyman's words from that dismissal of Wayfarer's complaint is coming back to bite him a bit, where I think all the legal commentators unanimously were like, he's overstepping his bounds because he's supposed to make a decision just on the law itself, not on the facts. And he was asserting facts, such as, and he did say, and he stated it as fact that, the Wayfarer parties then engaged in a smear campaign. And Lively's now saying, Judge, you've already basically ruled on this. And that's a problem. The court concluded that the source of the false narrative that formed the basis of defendant's defamation claim was Miss Lively's CRD complaint, which was itself predicated on her claims of sexual harassment and retaliation and was legally privileged. Yeah, but the New Times wasn't. Thus, the false and defamatory comments that supposedly form the lawful motive for defendant's adverse employment action are statements that are not only protected activity, but also legally privileged in a number of ways, including but not limited to California Civil Code Section 47.1. There is no evidence in this case that there is some other false and defamatory narrative about defendants that they were or could be defending themselves against. This framing, therefore, is an admission by defendants that their conduct against Miss Lively, if any, was based on her protected statements about their harassment and retaliation. That framing simply restates the same causal chain. Thus, defendants' desire to protect their reputations does not supply a lawful reason for purposes of a mixed motive or same decision defense. Okay, so, but no. Indeed, this framing is precisely how defendants have articulated it in their proposed same decision mixed motive instruction. Wayfarer Studios and Enzo's movie claim that their conduct was not directed toward or in retaliation against any protected activity, but was instead intended to protect their reputations and the film's reputation in the event of adverse media, which is lawful. Reputation-based considerations are relevant, if at all, to a different element, whether defendants' conduct constituted an adverse employment action, i.e., whether they were engaging in reasonable defensive measures. Miss Lively does not object to defendants raising a reasonable defensive measure defense to adverse employment action and agrees that defendants are entitled to a jury instruction reflecting that concept. We've got a footnote. The parties dispute the language of the reasonable defensive measures in jury instruction, which is set forth in the joint proposed jury instructions. That is different than a same decision mixed motive instruction because, however, although an employer has a legitimate interest in taking reasonably defensive measures in the face of a charge of discrimination, an employer must present a legitimate non-retaliatory reason for the adverse action, absent that protected conduct. California courts have repeatedly rejected attempts to characterize justifications that collapse into protected conduct as legitimate, non-discriminatory business interests. In Wallace, for example, the court explained that where an employer's asserted justification is inseparable from the protected characteristic or conduct itself, liability attaches notwithstanding the employer's belief that it was acting reasonably or in good faith. Once the justification collapses into protected conduct, the inquiry does not shift to motive balancing. The conduct is unlawful and the inquiry ends. Put simply, defendants' desire to protect their reputations does not convert their conduct into lawful behaviour for the purposes of a mixed motive or same decision defence, even if they felt that they were justified in doing so. A purported reason that flows directly from protected conduct is not an independent, non-retaliatory motive. We got a footnote. For this reason, Miss Lively includes the placeholder of poor work performance as an example of a type of lawful reason that might exist in the same decision mixed motive instruction, which is the example provided for in the CACI, lacking any evidence of any lawful motive for defendant's adverse conduct against her. I mean, Lively's saying, look, this might apply in the situation of poor work performance, but I mean, within days of the filming starting, Justin Baldoni had to go and have a word with her about her wardrobe choices because people thought they were so terrible. So, is that not poor work performance? Just to throw that back at Lively a little bit. Okay. By way of analogy, admitting to adverse action while invoking reputation protection as a justification is no different from admitting to insurance fraud by burning down one's house and claiming the motive was a legitimate financial necessity. The asserted motivation neither excuses the conduct nor severs the causal link between protected activity and adverse action. Miss Lively cannot be required to accept a public decimation of her professional reputation by defendants in service of their own reputational protection, particularly where the reputational risk defendants perceived was the public learning that she believed in good faith that she had been sexually harassed, and as a result of her mistreatment, she did not wish to engage in press or promotion alongside her alleged abuser, Mr. Baldoni. Yet, at the hearing, she was arguing that she wanted to engage with him, though, for the sequel. And because that was not happening, she wanted to claim that as part of her damages and lost opportunities. Defendants remain free to argue to the jury that their conduct never rose to the level of an adverse employment action because it constituted reasonable defensive measures. And do you know what? I'm going to go back to this sentence because it's annoying me now. Alleged abuser. We're calling people abusers just for saying that an outfit is sexy. Is that where we are now in society? That sentence there was written and approved by people who clearly have no idea what an abuser is. That is overly strong language. And I would be reminding Lively that the judge said that nearly everything she complained of did not constitute harassment, and the few things that could have were so low level that it was the mildest of the mild. Like, what are we even bringing multi-million-dollar lawsuits for over this? I hate strong language I hate language where it's overly strong and is just basically inflaming what is basically a trivial situation. And quite, in my opinion, quite frankly, it's an innocent situation too. If the jury finds that defendants engaged in an adverse employment action, defendants' desire to protect their reputations does not constitute a lawful independent motive, warranting a mixed motive or same decision instruction, nor can it insulate defendants from damages. I remind everyone, actually, the judge has already ruled on this, right? So either she is asking for, this is a motion for reconsideration, which I don't think it is, because she doesn't actually ask for the judge to reconsider, or this is purely for the headlines, because the defense is there now. The jury instruction is going to go ahead. So by writing this 4-page letter waffling on about how unfair it is and all of these things, and basically re-arguing her position on why she believed that she was in the right, and she believes that her, and especially using terms like abuser, should not get to make this argument. This is for the headlines. I'm sure I'll be back here doing a video later on the headlines. Ms. Lively therefore submits the proposed instruction with objection as inapplicable on the facts of this case, and reiterates her waiver objection and expressly reserves all further argument regarding the propriety and effect of any mixed motive or same decision defense at the close of evidence and thereafter. So she's saying we might appeal this if she loses, because this is improper, but she's not seeking reconsideration of the judge's decision to deny her motion to exclude this. Okay, so let's go and look at her proposed jury instruction, and then we'll take a look back at Wayfarers and just kind of compare the wording. Okay, so Plaintiff Blake Lively hereby submits the following proposed jury instruction pursuant to the court's directive at the April 28th, 2026 pretrial conference, under objection as waived and inapplicable to the facts of the case, as set forth in Miss Lively's April 29th, 2026 letter submitted concurrently herewith. Okay, so this is the actual instruction that she's proposing here. Same decision. Miss Lively alleges that Wayfarer Studios, A. Angeles movie, subjected her to an adverse employment action by 1. Discouraging and obstructing her ability to complain about a hostile environment. How did they obstruct her ability? She had lawyers who sent the 17-point letter, and she had her all-hands meeting at her home. I mean, where's the obstruction? 2. Attacking her character and professional reputation, including through a negative press and digital media campaign. 3. Threatening and or attempting to intimidate Ms. Lively and third parties. I think third parties should be kept out, because this is about retaliation against her. 4. Filing a frivolous and factually baseless retaliatory lawsuit against her because Ms. Lively engaged in protected activity by A. Complaining about or otherwise opposing a hostile work environment, B. Filing an administrative complaint or lawsuit, and or C. Because defendants anticipated she would do A or B, which are all unlawful retaliatory reasons. Defendants contend that their conduct was motivated by Miss Lively's poor performance, which would have been a lawful reason. Can I just say, when we listen to Claire Ayoub's recording, right, and bearing in mind that recording was done, I think it was August the 24th or the 28th. It was at the end of August, right? Lively keeps saying, oh, Steve Sarowitz has said he was going to spend $100 million, right, on destroying us, yeah, and he was going to protect the studio like Israel protects itself from Hamas, and all these inflammatory, exaggerated aspersions placed on the words of Steve Sarowitz, right, in that recording. But she's also saying, well, the smear campaign started on August the 9th. So if by I think it's August the 28th, if by August the 28th, Steve Sauerwitz is saying, hey, we might go and protect ourselves, we will defend ourselves if necessary, doesn't that suggest that the smear campaign hasn't started yet? So any spikes in negative online sentiment was actually organic. Sorry, that was just a thought process, and I have to get these things out while in the moment when I'm thinking it. It just like it's not, no, things aren't adding up. If you find that retaliation was a substantial motivating reason for defendant's conduct, you must then determine whether defendants have proven by a preponderance of the evidence that they would have engaged in the same conduct anyway at that time, even if they had not also been substantially motivated by retaliation. If you find that defendant's conduct was for a retaliatory reason, you will be asked to determine the amount of damages that she is entitled to recover. If, however, you find that defendants would have engaged in the same conduct anyway, even if they had not been substantially motivated by retaliation, then Miss Lively will not be entitled to reinstatement, back pay, or damages. Okay. So, the biggest issue I have with this is this. I think that needs to be taken out because it is more likely now than not, given this stipulation that Wayfarer have agreed to, that these third parties, who are they? Who is she referring to here? But it's likely that they're not going to be put on the stand either. If it's to speak about the allegations, like the sexual harassment allegations. If she's talking about, the fact that she sued Ryan Reynolds and Leslie Sloan and the New York Times, right, and they're the third parties because they were included in a lawsuit against her, then that is wholly irrelevant because, it's not that's not retaliation for protected activity. In that lawsuit included things like breach of contract and civil extortion. And Leslie Sloan and Ryan Reynolds were not engaged in any protected activity. And they were not sued because Lively was engaged in protected activity. Okay, let's compare Wayfarer's proposed instruction, although they may respond to this. So this proposed instruction is from the initial pre-trial motions back on the 10th of April. And then they got into a whole argument about it, which has led us to that letter. But the affirmative defense, Lively didn't have one. So defendants, Wayfarer's proposed instruction on this. In this case, the defendants have asserted certain affirmative defenses to plaintiff's claims. Even if the plaintiff proves all of the essential elements of her claims, the defendants can prevail in this case if they prove an affirmative defense by a preponderance of the evidence. When more than one affirmative defense is involved, you should consider each one separately, which I think is fair. I caution you that the defendants do not have to disprove plaintiff's claims by a preponderance. She always has an affirmative obligation to carry the burden of proof on her claims. But if the defendants raise an affirmative defense, the only way they can prevail on that specific defense is if they prove that defense by a preponderance of the evidence. Okay, so Lively's position on that. Plaintiff maintains that this instruction is confusing and misleading and simply not accurate. Defendants do not have any affirmative defenses as to liability. The affirmative defenses, which are mixed motive, same decision, and employees' duty to mitigate are only as to damages. It is not proper to instruct the jury on what the defendants don't have to do in the context of explaining the plaintiff's burden. And defendants say defendants are entitled to an instruction on affirmative defences. Defendants assert a duress affirmative defence to plaintiff's breach of contract claim. So, and they obviously withdrew that affirmative defence, the duress one. They withdrew that before the hearing, which is why we are only looking at the mixed motive, same decision, affirmative defence. So, Wayfarer's instruction is obviously, lighter on the inflammatory language, but, Lively is entitled to vehemently assert her case. But I am expecting Wayfarer to respond to Lively's proposed jury instruction, because I'm troubled by it. I also don't think, given that she was going to just say, right, here you go, here's my proposed jury instruction. She's not actually objecting to the defense anymore. She can't because the judge has ruled on it. But I mean, did it really need 4 pages of just, blah blah blah? Here's all the reasons why Wayfarer should not be getting this. I don't think so. I think I was purely headlines, and we will see later when the headlines come out. Hopefully that explains everything. So I still think that this stipulation, I know I've had a lot of people kind of really concerned or worrying that the judge is not going to be able to grant the motion for judgment on the pleadings. I mean, obviously, I don't know if he will or not. That's up to the judge. But I think by agreeing to the stipulation that there's a far stronger likelihood that he could and would, because, again, I go back to his order from the motion on summary judgment, where he effectively said in that, she does have a reasonable basis for believing that she was engaged in protected activity. So if Wayfarer was still maintaining a dispute on that point, then he wouldn't have been able to grant it. It would have been a fact issue and it would have gone to trial. So those 2 claims still could go. But we will see. He should be kind of dealing with that quite quickly, because everyone needs to know what's going on, what claims are moving forward, and what witnesses and evidence they need.